Good evening, everyone, and welcome to Ricago's Labour Codes webinar series. I am Charan from Ricago, and I'll be your host for today's session. Firstly, we thank you for being part of our discussion on one of India's most significant labour forms, the four labour codes. We'll just wait for one more minute as more participants are expected to join. While we wait, you can share in chat what you're hoping to learn today or your current understanding on the labour codes. Thanks for waiting. We'll start the session now. So while our previous session was postponed due to technical challenges, we are back with thorough preparation and committed to delivering an impactful webinar for today. So in the four labor codes, we have covered the code on wages on 8th December. And if anybody has missed that session, the recording is published on YouTube. You can access that. Today, we'll be covering the Industrial Relations Code, the Social Security Code. And the last code, the Occupational Safety, Health and Working Conditions, we'll be covering on 18th, which is this coming Thursday. As regular process, we'll be open for FAQs at the last. You can type your FAQs in the chat. We'll take it at the last. It gives me immense pleasure to introduce our speaker again, Mr. Vaibhakar, an HR and labor law specialist with over 53 years of experience. He has guided many of the organizations on labor law compliances and has authored multiple books in this field. We are truly honored to have him with us today. With that, I would like to hand over the session to Mr. Vaibhakar sir. I'll be presenting the screen and Mr. Vaibhakar sir will deliver the session for today. Sir, it's up to you.
Go to first slide, please. Yes. Participants, first of all, I express my regrets. There was some challenge in the last meeting. So I'm covering two sessions now. One is on social security, another is on industrial relations. Now this session is on social security. What is social security? That we have our own security, but the government bothers about the society. Now, what should be the good for the society? How to provide for that? How to encourage them to provide for themselves? That is all social security. Next. Next. This act is a code. That means the earlier acts were replaced. Those acts were merged into one code. These acts are 9. There is a list. I need not go through the list, but there are 9 acts. Next. The object of this is to provide income security, particularly in cases of old age, unemployment, sickness, invalidity, and work injury. You will notice that the income security is during the period when it is beyond the control of an individual. Old age, we cannot do anything. Unemployment, it is in the hand of others. Sickness, we don't know when it will come. Invalidity, we don't know. Work injury, we don't know. So all this for unforeseen circumstances, there has to be some security, some provision. That is the object. The salient features of this code are, why this code was amended this time is in India, 10% of the workers are in the organized sector, factories, and 80% workers are in the unorganized sectors. They are gig workers, maternity benefit, and loss of breadwinner by means of rights conferred on them. When in the family, the breadwinner dies, there is all mess-up in the family. So for that, we are providing. Next, please. Gig workers. This is a new term and it is used for the first time in the Indian courts. The gig worker is a person who performs work or participates in a work arrangement and earns from such activities outside the traditional employer-employee relationship. There is no employer-employee relationship. That is what we understand in the normal parlor. It is the person does something for other. It is, we can call it a contract. Both are on equal footing. Maybe one is stronger, another is weaker, but still it is a gig worker. He performs for some other person. Normally, a gig worker means a person who performs a job temporarily or someone who takes a part-time job on hourly basis. The concept of gig worker has been introduced for the first time under the ambit of labor laws. It was the need of the hour to define such category of workers that consist of a large number of freelancers which work on temporary basis. Now, further I will explain to you what are these categories, but understand it is not an employer-employee relationship. It is sort of a commission basis. He works for other person. He appoints some capital. It is not that everything is provided by the employer. He has something on his own. He works, he gets some job. When the person in charge gives him some job, he gets money and part of it he retains as his commission and part he transfers to the gig worker. Therefore, he is called the aggregator. I will explain to you further. Next. Platform workers. The code defines platform worker as a person engaged in or undertaking platform work. Most commonly, platform-based work is where workers earn money by providing specific services or to solve specific problems through online platforms such as Amazon, Flipkart, etc. These days, we have got many things available online, but it does not come as it is. There are some intermediaries, there are some workers in between. They work and therefore we get it. And that is what is a platform worker. He is provided a platform to work. Therefore, he is a platform worker. Obviously, why this is important for us to understand is how big is the problem. We should not look at it from any corner or any angle. It is a big problem for the government. They have to bring so many workers under the parlor of social security. Next. Unorganized workers. Unorganized means who are not organized. In the industry also, there are unorganized, but there are laws for them and they can take recourse to those laws, those provisions. But unorganized workers are home-based worker, not home worker. Home-based means, suppose there is a grocer shop and in the grocer shop, his son works. He is not an unorganized worker. He is a home-based worker. Now, he employs someone, then he is a worker, there is employer-employee relationship. Self-employed worker or a wage worker in an unorganized sector is an unorganized labor. There are many places where there is only one person and he is assisted by another person. These are all unorganized. Take the case of hamals, then take the case of shopkeepers, take the help of cleaners, etc. They are all unorganized. They are not organized. For them, there is no law so far. This is the law which has come for them. Next. This is a code on social security. Now, for them, you can understand these are scattered. There is no organization. There is nothing for them. We don't know how many are there. Where do they work? On what conditions they work? Therefore, government, if it has to do something for them, they have formed a board of 42 members. It is an all India board. Therefore, this large number. This is especially for unorganized workers. And this board consists of state government, central government, and aggregators. Now this, they will advise the government on what to do, how to go about for social security in case of disability. that is accident, he loses some limb or something, disable. Then accident insurance, health, maternity, and the fund will consist of. So for these things, the board will advise the central government, and accordingly government will organize it or implement it. The fund will consist of contributions from central government, state government, and aggregators. Aggregators, as I told you, is the person who gives work to these gig workers, and he takes the payment. The aggregator gets the payment and parts some part of it to the gig worker. CSR funds, you may know, every company who makes profit has to allot a specific percentage of their profit as CSR funds. CSR means corporate social responsibility. This is social responsibility. You are working, you are having an industry, and you are making profits at the cost of whom? Wherever you are located, the surrounding area is polluted, they get the trouble, and therefore you have to do something for them. That is corporate social responsibility. Corporate responsibility is there to make profit, to give employment, this, that. But social responsibility is this. Therefore, for that, for last so many years, the CSR has come, corporate social responsibility. So, for giving the social security to these workers, unorganized workers, the fund is consisting of contributions from central government, state government, aggregators, and CSR funds. Accident arising out of employment is made now liberal. Why? Because a worker at times requires help. If a worker is climbing on a ladder, he requires someone to hold the ladder. Otherwise, from the top, he may fall. Like that, many workers, while working, require a helper, an assistant. And so far, if there was an accident, the worker was covered, not the helper. But now, the co-worker, it is given a general term, not as an assistant or helper, but a co-worker who is traveling with him, he will also be covered. If employer has neglected to be registered, even then, ESIC will make all expenses. ESI Act is now applicable where 10 or more workers are or employees are employed. Now, if the employer does not cover himself under ESI, or he is covered but he fails to pay the contribution. After all, ESI gives them benefits out of contribution only. And when they do not receive contribution, so far, ESI was telling that we have not received the contribution from your company, we cannot give you the benefits. Now, not so. Now, even if the employer has not covered or failed to pay the contribution after coverage, then the ESI will give him all the benefits in the first instance and then recover it from the employer. Because the person, the worker, needs that help, then only he cannot wait for the company to pay the contribution or for the ESI to recover the contribution from the company. ESI has got facilities. After all, they will get it from the employer later on with interest and penalty. So it is their duty, and accordingly, they will do it for the workers. So this is real social security. Even if you have not paid, the ESI corporation will take care of you. Next. ESIC will now be concerned about insanitary working conditions. ESI gives benefit for what? For health, for illness, for accident. Now, how does illness develop? It is because of the working conditions. The smoke, the fume, the heat, the light. There are so many things which trouble a worker if it is not proper. Now, because of that, the worker falls ill. He claims from the ESI corporation and he gets the sickness benefit. Therefore, ESI is now saying that we will visit your premises and we will see if there are any insanitary working conditions and we will tell you to improve upon it. That right the ESI corporation has taken upon itself. Dangerous occupations. In past, report was necessary only when lost time accident was there. Lost time means 48 hours. There are accidents which are minor, which are major. A minor accident, for example, a small burn or a small cut, it is an accident by definition. But the person does not go home. He can have a bandage and start working again. So he is away from work for about say 2 hours. That is not lost time accident. But if there is an accident because of which he has to stay away from work for 2 days or more, then it is called a lost time accident. And therefore, it was reported only when there was a lost time accident. Now, since it is a social security in its true sense, a record of all employees, their wages, facilities, dangerous occupations, display of notice boards, and every report is necessary to be kept in the register. It is not that when the accident occurs, things will move. This is called prevention. This is called security. Let it not happen as far as possible. After all, when we are working in a factory, accidents are most likely. We cannot avoid it 100%. But we can have proper record, we can have proper arrangement, and for that, this register record is to be maintained all the time, not only at the time of accident. Right? Next. In Provident Fund Act, there was a limitation on wage. What was the limitation? 15,000 rupees. Now there will be no limit. In a sense, if one was getting basic and DA above 15,000 rupees, he was not covered under PF Act. But now what will happen is he will be covered. His contribution will be limited to 15,000. He will not contribute on his actual salary, but his contributions will be limited to 15,000. But he will be covered under Provident Fund Act. It was not before. In Employment Exchange Act, employers were to notify. The act was Employment Exchange Compulsory Notification of Vacancies Act. It was compulsory, but no employer used to inform the employment exchange. Why this employment exchange was formed by the government? Simply to collect the information about vacancies and employment. When politicians say there is mass unemployment, on what basis do they say that? It is on this record. This record is collected from various centers and sent to the central government, and they can tell them the figures. So earlier, the notification of vacancies was neglected by the employers. Now it has to be informed every vacancy. What happens? It helps the central government to plan what industries, what position, how many vacancies are there. That information the government gets. That is very useful for planning. Now this is real social security. We all know a few years ago there was pandemic, there was lockdown. Industries were closed, no wages, therefore no contribution. But now, in case of pandemic or natural calamity like flood or anything, the government will grant concession in payment of contribution of Provident Fund and ESI up to 3 months. Up to 3 months, You need not pay the contribution. Still, you will be covered. You will get the benefits whenever necessary. This is real social security. For establishments employing less than 10 employees, what do? These are very good schemes actually, Provident Fund and ESI. But there are misconceptions. People misguide others. Therefore, if the employer has less than 10 employees, this act is not applicable to them. But if the employees and employer decide jointly that we will implement these acts and we will contribute, they can do so by making an application to the proper authorities. PF and ESI both. Even if they have got less than 10 employees, they can get covered. Otherwise, there was a provision that if you had more than 10 employees, the act was applicable. And for some reasons, if your employment falls below 10, the act continues to apply. That was the provision before. But now the provision is below 10, you can apply and you can get yourself covered. Next. Registration. The code provides the compulsory registration of every unorganized worker, gig worker, and platform workers to avail the benefit of the concerned scheme framed under this code, subject to the fulfillment of the following conditions. Now, for all this, giving the social security, whom to give is a big question. Identity card. And that identity card can be only when the worker registers himself. There is no employer for him. Then how does he get recognized that he is a worker, he will pay contribution and he will get the benefits? That is the provision of registration. Every worker has to register. Then he will get a registration number, the I card. And then whenever there is an occasion of mishap, he can get the benefit from the ESIC and from the Provident Fund. The conditions are he has completed 16 years of age or such age as may be prescribed by the central government. 16 years is child labor is prohibited. Children are below 18 years of age. But now because of some reasons, 16 years is understood. Therefore, they are saying below 16 years is a child labor that is prohibited. So there is no question of giving him any registration. He must be above 16 years of age. Now, as of today, December 25, there are so many gig workers. They may be 50 years old, they may be 45 years old, they may be 60 years old. Whatever their age, they can register now. And second condition is he has submitted a self-declaration containing information prescribed by the central government. He has to submit some information, obviously, because without that, he will not be registered. Even eligible worker is to make an application for registration. Existing workers. Every eligible worker, every person, if he does not register, he will not get the benefits. That is the importance of this registration. We register at many places. This is registration for Social Security. Then in that, they have now made compulsory the Aadhaar card. There are so many, accepted information which are recognized. Aadhaar is one of them. They say with the Aadhaar card, maybe some other documents are also called for. They will prescribe the form, and in that form, every worker has to register. That is called the rules. In the rules, they will say who is the registering authority, how to register, what are the forms, what are the documents to be supplemented with the forms. That they will say when the rules come. Now it is only the code. But this provision is there and it is bound to come. Next. Employees Provident Fund. The code has revised the applicability of the Employees Provident Fund. The Employees Provident Fund will apply to the establishment employing 20 or more employees. The central government may establish the Provident Fund where the contribution paid by the employer to the fund shall be 10%. Now it is 12% of the wage for the time being. Now in Provident Fund contribution, they have reduced the contribution amount. Earlier it was 12%, now it is 10%. So it is a saving for the employer. Employee state insurance of the employees and the employee's contribution shall be equal to the contribution payable by the employer. This ESI, the contribution is now 1.75% by the worker and 4.75 by the employer. Now, in the Provident Fund, at least they have said 10%, subject to the condition that employer is not under the obligation to pay more than 10%. Now also that provision is there where the employee applies to the Provident Fund organization that he wants to contribute more than 12%. There are employees who get more salaries, those who do not require, but it is a saving and it is tax-free. So they contribute more than 12%. But if he contributes more than 12%, employer need not contribute more than 12%. Employer will contribute only 10% in the Provident Fund. That is the provision that we have to understand. It was there before also, now also it is there. Only thing is the rate of contribution will change slightly. Next. In the ESI, it was and it is that where there are 10 workers, that is a factory. In the factory, if 10 workers are working with power, it is covered under ESI also. It is also be applicable to the establishment which carries on hazardous or life-threatening occupation as notified by the central government. Central government issues a list which are the hazardous operations. There is a hazard in working. There is a likelihood of danger while working there. And life-threatening, those who work on the height, if they fall down, they lose their life. So such occupations where they are being operated, even if the number of employees is less than 10, ESI will be applicable. Because those workers cannot be left unattended. Just because there are no 10 or more employees, it is not covered. It should not happen. Therefore, if it is a hazardous or life-threatening occupation, then ESI will be applicable. Even if a single employee is there, it will be applicable because it is a hazardous operation. It is a life-threatening occupation. The code covers the gig workers and the platform workers also. They may fall sick. They may have a road accident. They may lose their limb. All these requires security. Now what happens if they meet with an accident? There is no one to take care of them. It will not be there henceforth. If the employer fails to pay ESI contribution, the ESI employees may pay the benefits to the employee and recover it from the employer later on with interest and penalty. That I have told you before also. But this is about ESI. So you will understand from the previous discussion that it is social security. And the object of social security is to help people. Why they require help? Because they do not understand. In our country, we have to tell them, we have to teach them to save for the future. That they don't understand. Whatever they get, they spend it. Next day, they are broke again. Therefore, this compulsory savings for them. Next. Gratuity. Why it is called gratuity? Because it is a gratuitous payment made by the employer when an employee is separating. When in our office or in our group, anybody is transferred or anybody is retiring, we hold a ceremony and we give him some gift contributed by all of us. That is gratuity. Gratuity, how it is made by law, I fail to understand. It is a gratuitous payment. The employer is happy with the services of the employee and therefore he gives something. That is actually the meaning of gratuity. But here we have got the law for that. Gratuity is applicable to every factory, mine, oil field, plantation, port and railway company and every establishment in which 10 or more employees are employed. Right? So for like ESI, Gratuity Act is also not now applicable where 10 or more employees are there. They will pay gratuity to the eligible employees. Gratuity is payable to an employee on the termination of his employment after he has rendered continuous service for not less than 5 years. There are two concepts in gratuity: completed year of service and continuous year of service. Continuous means without a break. And completed means in which year he has worked for 240 days. If he has not worked for 240 days, that is not a completed year. He should be in the continuous service for 5 years without a break. Out of those 5 years, if he does not have a completed year of service in a particular year, he will not get gratuity for that year. Because for each completed year of service, he gets the gratuity. So the termination of employment, termination is what? Termination is the separation of the employee from employment for any reason. That may be retrenchment, that may be retirement, that may be resignation, that may be he being disabled, whatever is the reason. He separates from the employment. At that time, if he has completed this work continuously for 5 years, he is entitled to gratuity. In case of working journalist, the gratuity will be payable after 3 years. Why so? Because their conditions of work are different. The Social Security Code entitled the fixed term employees also employed for a fixed duration, that I will explain to you in the next IR code, to receive gratuity on pro rata basis. Why so? Why for fixed term employees, whatever period he has worked, he will get gratuity, not 5 years, not 3 years. The simple reason is, try to understand it this way. The employer is not allowing him to complete 5 years. The employer is dismissing him, separating him from the employment before 5 years. If he had not separated, if the fixed term employment is for 6 years, he will complete 5 years. But you limit it to 2 years, 3 years, 1 year, and so on. Therefore, he cannot complete. He goes to another employer, again 2 years. He goes to third employer, 3 years. He will, in his lifetime, he will not get gratuity. Therefore, now the government has made the provision that for fixed term employees, for whatever period they have worked, they will get the gratuity proportionate. Now, this 5-year term is relaxed in case of death of worker. He dies before 5 years, then also he is given gratuity. Just because even if he wanted to complete 5 years, he is not able to complete 5 years. That is the sole reason. So this is the meaning of gratuity. how it is extended to working journalists, to fixed term employees, and what are the provisions for regular employees. They are some different. Okay, next. Maternity benefit. This is very important, but very troublesome for the employers. Maternity benefit is essential. Gender neutrality. Therefore, we employ women. But women only get maternity benefit. Yes, they suffer, no doubt about it. But what happens is the conditions made by the government are such that it is misuse of the facility. Try to understand it. No woman shall work in any establishment during the 6 weeks immediately following the day of her delivery, expected date of delivery that we say, miscarriage or medical termination of pregnancy. The doctor gives a certificate that on so and so date, the possible delivery will take place. 6 weeks before that date, nobody can be employed. Every woman shall be entitled to the payment of maternity benefit at the rate of average daily wage for the period of her actual absence. Her regular wage has to be paid to her, even though she is absent and she is on medical maternity benefit. Every woman shall be entitled to maternity benefit if she has actually worked in an establishment of the employer from whom she claims maternity benefit for a period of not less than 80 days. Now, this is very troublesome. 80 days is how many months? About, say, 3 months. Now, 3 months she has worked, and out of 3 months, now she is getting 6 weeks, that is 1.5 months as paid leave. And further, total 26 weeks. Prenatal and postnatal. This is what is troubling the employers. Because many times what happens is, it is away from work, and therefore these women employees, they work for other companies and they get employment. They get the benefit from here, resign and go to some other place. Then for 3 months working, the employer is giving her 26 weeks benefit. Is it not burden on the employer? It is. But the government wants it, we have to do it. And then when the conditions are very stringent, there are via medias. There are shortcuts. What do the employers do? They terminate the woman. They say, you come afterwards, we will re-employ you again. They tell the woman that we will give you half pay. They tell the woman that you go, you come back, then we will give you the benefit if you stay here for another 2 years. These are the violations of law. But the conditions are such. Employment industry is not a charity. They give everything out of profit. They have to make profit. Now somebody will say that maternity benefit is only for 2 deliveries. Okay. But then it restricts the employment of women workers. This is the trouble for the women only, that the employers do not employ lady workers because maternity benefit has to be given. The maximum period for which any woman shall be entitled to maternity benefit shall be 26 weeks, that is 6 months. In a year, there are 52 weeks. Half of it is 26 weeks. Of which 8 weeks shall precede the expected date of delivery. Earlier, the condition is for 6 weeks, she will not be employed. Now here 8 weeks is what? She can ask for leave. So she goes on paid leave. This is the maternity benefit. After all, these are part of our society. We have to take care of them, no doubt about it. But why it should be a burden on the employer? Next. Maternity benefit additional is, in addition to the maternity benefit of paid leave, that is 26 weeks, every woman is entitled to medical bonus up to 3,500. This medical bonus is to be paid by the employer. Why? Because she requires extra care, medicines. So some amount is given to her to take care of her, because once the delivery is there, then it is no use we take medicines afterwards. What is required to be taken before. Confinement and postnatal care is not provided by the employer. In case of miscarriage or medical termination of pregnancy, a woman shall be entitled to leave with wages at the rate of maternity benefit for a period of 6 weeks immediately following the day of her miscarriage. In case there is no natural delivery, then 6 weeks after the event, she can get the benefit. Not like 26 weeks in case of maternity benefit. Next. Thank you. Now, if you have got any questions on Social Security, you can note it down or put it on the chat box. We will take the questions at the end. Now,
Yeah.
I go to Industrial Relations Act.
Yeah. So we'll just take 1 or 2 questions on Social Security code.
We can, but then if
Yeah.
the questions lengthen, then we will not have sufficient time for Industrial Relations Code.
Sure. I'll just take 2 questions just to make sure people know that we are answering the questions also. I'll just take 2 questions.
Okay.
Yeah. Is the Social Security code applicable for software companies also?
That we will see only after the rules come, because the government can make it applicable to any employment. That is the provision. So if they make applicable to the IT industry will be covered. That
Okay.
cannot be told right now.
Okay. Yeah. One more question. Under Social Security ESIC, if an employee fails to inform the employer about the accident within 48 hours, what can the employer do in favor of employee?
See, why he could not inform the employer has to be seen. What was his inability? Is there any justification for that? If there is a justification, we can always tolerate it. But without justification, by negligence, if he has not informed, employer will not be responsible. When the problem comes up, the employee will have to justify why he could not or why he did not inform within 48 hours.
Got it. Yeah, we have almost like 10 to 15 more questions that we'll take after we complete the IR code as well. So now I'll show the Industrial Relations Code PPT. Please confirm if you can see my screen.
Yes.
Yeah.
First, opening slide I can see.
Yes, just
now,
a minute.
Before we go to the next slide, what I would like to impress upon you is there are 4 codes, right? Wages, Social Security, occupational health and safety, and industrial relations. All
Yes.
other three codes are executive codes. They are only to be executed. There are no disputes. But industrial relations code is the most important because there is a relationship. And when that relationship is strained, there is dispute. Why the industries go on strike or lockout, or why there is trouble, why people leave. These all reasons are because of the employer-employee relations that is in this code on industrial relations. Now there are two terms, industrial relations and employee relations. What is the difference? Difference is employee relations are one-to-one. I deal with one employee, his grievance, his trouble, his action. Industrial relations are industry-wide, company-wide, like charter of demands, is company-wide. But I am not given promotion, is an employee relation. I hope you have understood this difference between employee relation and industrial relation. Okay, next. Why this code? The importance of this code is we are a developing country. We want foreign investment, right? How will foreigners come here and invest? Because our laws were so strict. Earlier, or even now, until this act are implemented, the old laws prevail. In the Industrial Disputes Act, if you have got more than 100 workers, then for closure or retrenchment or layoff, you have to seek permission of the government. And government never gives permission. Who will come to and invest here? Therefore, it is not called ease of doing business. If there is ease of doing business, then the foreigners will come here and invest. That is the reason why this code is made like this. Ease of compliance. Now you are running an industry, you are employing persons, therefore you have to comply with the laws applicable. Earlier, 52 plus acts. Out of these, central government, 29 acts. Every act was different. Every act there is a separate registration. Every act there is a inspector. Every act there are some registers and records to be kept, returns to be filed. That was a huge task. The HR department's work was mostly in this only. But now with the code, in every code there will be only one registration and one return. Isn't it ease of compliance? Only one return. It will contain whatever information they want, but only one return to one authority in a year. That's all. Organized job opportunities. Now they have uh, included many provisions for the so-called gig workers and platform workers, fixed term employees. So the job opportunities for them are now organized. Earlier, they were not organized. If an individual wants to have some policy, he could have taken it, but not by his employer or by government. Increased government revenue through taxes. Now, in this code, we will see later on, the violation of the provision attracted a fine of 5,000 rupees. Now in this code, it is 50,000 rupees. Isn't it a revenue for the government? Everywhere there are some violations of law, minor laws. Because it is not possible to run any industry with 100% compliance. But then because of that, if the inspector comes, and there are many difficulties for the employers and the employees that we will see later on. But this code was made for these four reasons: ease of doing business for the foreigners, ease of compliance for the employers, all employers, job opportunities for masses, and increased government revenue through taxes. Okay. Next. Some important points to be noted before we go into the details of this IR code are wages. Wages include house rent allowance, conveyance, and other allowances. It is widened term now for giving benefit. Inspector cum facilitator. Now this is very noteworthy. Why? Because it is not an inspector. Earlier the inspector used to come and tell you something, but now he is a facilitator. Facilitator for whom? For employer also and for employees also. Advisory role to the employers, unions and workers. Now what if the workers are ignorant and therefore the employer was running his show? Now the facilitator comes and tells them. They will make agitation. It will be a trouble for the employer. So this is the threat of inspector cum facilitator. Now compounding of first offense. This is something, concession or solace for the employer. Compounding the first offense by paying 50% of the maximum fine. If the fine is 50,000, he can go and say, galti ho gayi. Then they will say, pay 25,000 rupees, go out. That is compounding of offense, but it is only first offense. Second offense, no compounding. Only in the first offense, pehli galti maaf, bas. After that, no concession. These three are important things to note. What are the changes in the new code? Next. Some comments. Critics are always there and they go on making comments. One comment is they are not truly consolidated. All the laws are combined together. What was the difference? Earlier the laws were there, now the laws are there. Key definitions vary from code to code. There are 4 codes: wages, social security, industrial relations, and occupational safety and health. In 4 codes, the term employee is defined differently. In one code, whatever acts are there, the same definition will apply, no doubt. But in different codes, different definitions are there, and people are covered, not covered, to what extent covered. But actually, every code has an object. For that object, if those kind of employees are not required, then why give them or why mention the benefits for them? And challenges for interpretation. This is a new code. Some new concepts have come, some new nomenclatures have come, some new positions have come. How to interpret them? It will be left to the courts. You will remember, or you may have heard, that when the Industrial Disputes Act came in 1947, for the first about 10 years, there were disputes about whether he is a workman or not, whether it is industry or not. There is a famous case of Bangalore Power and Research Station case from your state only. What did the court say there? That if any organization has got 10 verticals, 10 branches of work, and out of that, even one is an industry, the entire thing is industry. So this is an interpretation by the court. So this new code has come, new concepts have come, the government has made it with some objective, but it is left to the interpretation by the judges. So there will be lot many disputes on this IR code. Let us see what actually happens. Next. The acts which are included in this are Industrial Disputes Act, Trade Unions Act, and Industrial Employment Standing Orders Act. You may notice that all these acts were at the time of independence or prior to that. These acts were made by the Britishers. Next. Fixed term employee explained. This is going to be a disputable fact for interpretation. What is a fixed term employment? Now when we employ on probation, then we make him permanent. Then unless he is terminated, he remains till his retirement. There is no term of his employment. There is only period or event of his separation, that is retirement. But here now it is a fixed term employment. It can be compared to a certain extent with a temporary employment. We appoint a temporary person for 3 months, 6 months. That is a fixed term employment. After 6 months, that employee goes away. For fixed term employment, now it is a different concept that in your regular employment, you can appoint fixed term employees. There should be a written contract for the fixed period. On what terms he is employed, what wages, what other conditions of service, what location, all this comes in a contract. And these terms and conditions, benefits should be same as the permanent worker. Then why have that fixed term employment? If it is going to be same as the permanent worker, we can have a permanent worker only. Why have a fixed term employment? That is because you answer me, when is the sale of umbrellas more? In the rainy season. So when the month of April, May comes, the umbrella manufacturers have got increased work. But come October, people will bundle their umbrellas and keep it aside. That is a temporary increase in work, and therefore I appoint fixed term employment. This is an example that I gave you. He is employed on a fixed term, 4 months, 2 years. I am constructing a bridge. The bridge work is going to get over. What do I do with that employee after that? So I have a fixed term employment. After the bridge work is over, he goes away. He cannot claim employment in any court. Eligible for proportionate statutory benefits. The second one also the same thing, term same as permanent worker. He is eligible for gratuity. In the last social security, I told you, fixed term employees, we do not allow him to complete 5 years. And therefore, he is entitled for gratuity even before 5 years, whatever years he has worked, 2 years, 3 years, 4 years. So these are the fixed term employments. Now, where will they be employed? Is it allowed or not? These are all disputable points. All these unions are now vehemently arguing that the nature of industry will change. Everybody will have fixed term employment. ले लो 2 बरस के बाद उसको कोई हक नहीं है employment का. So that is going to be a disputable fact. Okay, next. Trade union. Now, Trade Union Act came in 1926. We all immediately understand that trade union is for the workers. No, it is not so. Trade union is for every trade. Even the employers union is a trade union. There are unions, but mostly we understand and we deal in trade unions as a workers union. Let us examine that way only. It is mandatory for every union to register. In the present law, it was not necessary. You can have a union, you can have the contribution, you can have the managing committee, everything, but you need not register. You will not get any benefits of registration. But that choice is not left now. If you want to operate as a union, you must register. That is a compulsion for every union. He may have 10 employees, 5 employees, 50 employees, 500 employees, whatever it is. You are operating as a union, you must register. And why this registration necessary? Because when it comes to negotiations, there are conditions. There is a negotiating union and there is a negotiating council. If you want to be in that union or council, you must have been registered. Who is a negotiating union? It is a single union who has got 51% membership in the industry. Obviously, he has the majority. Therefore, it can negotiate for all workmen. And only that union can negotiate. Other unions which have got less than 51% or 50% membership, they don't have any right to negotiate with the employer. But what if no union has got 51% membership? Then whatever unions are there, they must have at least 20% membership. And depending upon their membership strength, representatives will be there in the committee. That is a negotiation council. When there is no union with 51% clear majority, whatever unions are there, proportionately, they will get a seat in the negotiation council. So employer then cannot negotiate with one union. He will have to negotiate with all the unions. Next. Standing order. Standing orders are what? Standing orders are orders which last forever. Therefore, they are called standing orders. These standing orders were in the Industrial Employment Standing Orders Act. Now in this code, they are as a standing order only. Earlier, in the Industrial Employment Standing Orders Act, they were applicable where 100 and more workers were engaged. Now they are applicable to 300 and more workers. What is the meaning of this? The meaning of this is those who have got more than 300 workers, they will be governed by the government. Standing orders will be the model standing orders of the government. But if you do not have 300 workers, you are less than 300, you can have your own rules. Definitely, it cannot be whims and fancy of the employer. There are so many principles, culture, practices. The standing orders have to be in line with them only. But then employer has a choice. He can frame his own standing orders. It is a tedious job, no doubt about it. But there is a provision for him that he can tell the employees in their appointment letter only or by way of notice that the provisions of Standing Orders Act will be applicable to you. Khalas. All those industrial employment standing orders, the model standing orders will be applying to them. A simple thing. But if not, he wants to make his own rules. What rules? Again, a disputable matter. Now, what is the period of probation? In the standing order, it is 3 months. The employer can say 6 months probation. That will be legal if he makes his own rules. Suspension. Now, in the standing orders, the punishment for misconduct is either a warning or suspension up to 4 days or dismissal. Now he can suspend him for 6 months. These are the changes he can make in the rules when he makes himself. Now, other thing is those who were having the model standing orders earlier, say 200 workers. In the old act, before the code, the standing order act was applicable to them. Now it says 300 and more. They are not 300 and more, they are 200. What happens? What is their position? Now, in that, there are two provisions. One is whatever is the practice will continue. There will be no change. That is one. And secondly, the employer and the employees can amend those provisions which suits them. Because now they are less than 300, and in the new code, the act is applicable to employers more than 300 workers. I believe about 80% of the industrial employments are below 300. I may be wrong. Examine yourself. How many employees you have? 300 and more or less than 300? Not yet shared by government. What are the standing orders? The government has not shared it. Earlier in the standing order act, there was model standing order for manual and technical workers, for clerical and supervisory workers, and for working journalists. Now, with the consolidation of the acts, the standing orders will also be consolidated by the government most probably. And when they will publish, that will be applicable to establishment with more than 300. If you are less than 300, you can have your own rules. Next. Strikes and lockouts. The interesting part of the IR code. In the earlier ID Act, one could go on strike, flash strike, pen down strike. Various names were given to the strikes. But only in public utility services. And those public utility services will be declared by the government. The strikes had a condition that 14 days notice must be there. Within 14 days, nobody will go on strike. And when the union gives a notice for strike, the employer straight goes to the labor office and the matter is admitted in conciliation. Then during the proceedings, no strike. That was only for public utility service. Strike and lockout. There is a mirror in between. What provisions are there for strike? The same provisions are for lockout. So when I say about strike, it automatically applies to lockout. So in this code, strikes are prohibited. No strike. Why? Because we want production. We don't want work stoppage. A corollary to that is, if the workers have some grievance, how they can be solved? Either the judiciary must be prompt to settle any case within 3 months, or there should be a grievance committee in the organization which can take care of their difficulties. If that is there, who will want to go on strike? That is also there. But for strikes, this is the provision now. Strikes are prohibited, and that is what all the unions are now craving. Flash, lightning strikes are a history. Notice is required to be given 60 days notice. And within 60 days, they can go on strike any day. If they give a notice and 60 days are over, that notice becomes void. They will have to again give a notice if they want to go on strike. So this notice is required 60 days. And by giving 60 days notice, first 14 days, no strike. From 15th day to 60th day, they can go on strike. if they have given a notice. But it is also futile because when the notice is given, immediately the matter will be taken in conciliation. Strike or lockout will be illegal. Concerted casual leave. It is called also mass casual leave. En masse, the employees apply for casual leave. They have got the balance, and casual leave is for casual reasons. It cannot be applied in advance. So they used to apply for leave. In the Payment of Wages Act, there was a provision that if 10 or more employees concertedly remain absent on any reason, then employer can deduct wages up to 8 days. If they go on strike for 1 day, he can deduct wages up to 8 days. Up to 8 days, 3 days, 4 days, 5 days, whatever he feels. That provision is not there now. Concerted casual leave will be prohibited. Employees cannot go on strike like that. They will have to give 60 days notice. And conciliation is mandatory. You don't have any choice. Immediately the case is taken in conciliation, then your right to strike, right to lockout is gone. Therefore, there will be no strikes, let us hope so. Those who are, little senior, 60 years or around, they will notice that until 1990, how many strikes and lockouts were there? After 91, it has slowed down, and now we rarely see strike or lockout. What are the reasons? The reasons are very many. But the number of strikes and number of lockouts have considerably reduced. I am operating from Pune. In Pune Labour and Industrial Court, I can tell that earlier about 900 cases used to come to Labour and Industrial Court. Now hardly 200 cases come. Why? Because of circumstances change. Firstly, contract labor. In big companies where there used to be a strike or lockout, employees, when they retire, they don't replace that with another employee. They take a contract labor. Contract labor does not go on strike, or if he goes on strike, his service is terminated. So this is the provision about strike and lockout. Where there are permanent employees, there is a problem for the employer also and for the employees also. Next. This is a very good provision, I will say. If you retrench a worker, why? Because you don't have that activity now. I again give the same example of umbrellas. What is an umbrella? It is a cloth and it is the structure. They are not manufactured under the same roof, under different roof. Now, who is dealing in cloth? He can be dealing in other areas also where cloth is required. But when the rainy season is over, that business is down. Therefore, he retrenches his workers. That means I don't have a business. Right? He has the right to retrench. Of course, there are some provisions that he had to take prior permission of the government, this, that. But now that consent is not required of the government. But when he is retrenched, what he will do outside? If he wants to get employed anywhere, will he get? Because he has developed some skill here, whether the same skill is available in the market. Now, if he has to learn some different skill, he requires help. He will be given the retrenchment compensation, gratuity, bonus, these, that. He will have some funds. But additionally, he will be given 15 days wages, last wages that he was drawing. Why?
Sir,
Huh?
sorry to interrupt. We are running short of time. So if we
Huh?
can complete it in next 2 to 3 minutes, we'll have time for Q&A.
Okay, okay.
Sorry to interrupt. Yeah.
Huh. So that social security provision, we can say, is here in reskilling. The retrenched worker has to be given this benefit so that he can learn and get other employment. Next. Next. Compounding. What is compounding? Compounding is composition of offense. Compounding is that when there is a fine of 50,000 rupees, it is first offense, pay 25,000 and get rid of it. That is compounding. But what is the pros and cons of that? Pros is that he need not go in argument. He did not go to prison. He pays 25,000 and comes out. But what are the contra things? Contra thing is, most importantly, you may not have noticed, he admits his fault and therefore it is compounded. In writing, he is admitting that it was his fault, therefore it is compounded. That is the contra thing for him. Next. Grievance settlement. This is very, very, very important. If you have the grievance settlement, then there will not be any disputes. In the grievance redressal committee, there should be 6 to 10 members, equal numbers between employer and workman, and chairperson on rotation basis. Rotation means what? 1 year the employer's representative to be the chairman, next year the employee's representative will be the chairman. And appeal to conciliation proceedings. If in the grievance redressal committee a decision is given, the worker need not wait at that. He can go to conciliation in appeal. And industrial tribunal, there are 2 members now. Earlier, the industrial court, labor court had only 1 judge. Now that will be abolished and there will be 2 members, 1 judicial and 1 administrative. I was welcoming this provision because administrative member, if he is worked in industry, if he has expertise of working in an industry, it will be good justice. But the government has said only the undersecretary will be the administrative member. How many undersecretaries are there? What will they understand about the industry? And how many industrial tribunals will be there? Again, there will be a delay in the justice. Okay, let us see.
Also, before we close, a quick reminder, our next session will be happening on Thursday, 18th, where we will be covering occupational safety, health and working conditions code. Also, just to give you a heads up, we will be providing a free FAQ document on labor codes on the Thursday session. So don't miss that session. We look forward to seeing you on Thursday at 3 p.m. Have a great evening. Thanks to our speaker for his insightful talk. Thank you.
Thank you.